Specialist Chambers is now in session. Please be seated.
Good afternoon, everyone, in and outside the courtroom. Mr. Court Officer, would you please call the case?
Good afternoon, Your Honours. This is case number KSC-BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you very much, Mr. Court Officer. Now, I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office, please.
Good afternoon, Your Honor. The Specialist Prosecutor's Office is represented today by the Specialist Prosecutor Jack Smith, myself, Cezary Michalczuk, Prosecutor of the SPO, on my left-hand side, Sylvia Diascoli, Associate Prosecutor, and Claire Lawson, Team Leader Legal Officer for the SPO. Thank you.
Thank you very much. Now I turn to the defense, please.
Yes, Your Honor, good afternoon. My name is Julius von Bonnet, counsel for Mr. Mustafa.
Thank you very much. And I note that for the record, Mr. Mustafa, your client, is also present in the courtroom. And for the record, I am Nicholas Guillou, pretrial judge for this case. On 19 October, I scheduled a hearing for today for two purposes. First, to allow Mr. Mustafa to enter a plea on the charges brought against him by the prosecutor and confirmed by the pretrial judge. And second, to hold another status conference in this case. I will begin with the accused plea. Mr. Mustafa, during your initial appearance on 28 September, I informed you of the need for you to plead guilty or not guilty on the charges brought against you in the confirmed indictment. In the exercise of your right, you indicated that you did not wish to enter a plea immediately at the initial appearance. I reminded you that, pursuant to Rule 92, you must enter a plea within 30 days of your initial appearance, and that if you fail to do so, I will enter a plea on your behalf of non-guilty. Today marks the 30 days deadline. Before we move forward, I would like to ask counsel for the accused whether you received the disclosure package from the prosecutor, which was due on 23rd October, in accordance with my framework decision on disclosure of evidence and related matters issued on 9 October. And for the record, this concerned the disclosure of materials submitted by the prosecutor in support of the confirmed indictment, as well as the confidential version of the detailed outline. Mr. von Bonnet.
Thank you very much, Your Honor. I did receive those materials, and in good order. The issue of translation is an issue that I will address later in this status conference, but for the moment I'm happy to receive those documents. In addition, I want to express that Mr. Mustafa will have some introductory notes before he gives his plea. Thank you very much.
Thank you very much, counsel. Mr. Mustafa, in a few moments, I will ask you to enter a plea of either guilty or not guilty on each count of the confirmed indictment. I would like to remind you that it's a very important decision. Should you wish to plead guilty on all or some of the counts, the proceeding in relation to those counts will go directly to a trial panel. There will be no evidence presented and no discussion on your guilt or innocence. In that case, the trial panel would simply determine whether your guilty plea was voluntarily made, whether you understand the consequences, and then move directly to sentencing. Alternatively, should you wish to plead not guilty on all or some of the counts in the indictment, the pretrial proceedings will continue in relation to those counts, with a view to preparing for those counts to be litigated before a trial panel. At trial, a panel would then admit evidence, hear from witnesses, and receive submissions from the parties. The trial panel would then decide whether the prosecutor has proven your guilt on those counts beyond reasonable doubt. I will now ask you to enter a plea on each of the 4 counts in the confirmed indictment. I recall that these charges were already read out to you by the court officer during the initial appearance. Mr. Mustafa, before you plead guilty or not guilty on each count, do you want the charges to be read out again today by the court officer? And I'm just asking you if you want them to be read out, not for the plea now and not for your introduction, just if you want them to be read out again by the court officer. Microphone, please.
Nderuar zotë gjykatës,
Your Honor, before I express myself on pleading guilty or not guilty, I would wish to say a couple of words. As a matter of fact, I don't need anyone to once again read the indictment to me because I properly understand the counts that I'm charged with. Thank you.
So before you plead, you now have the floor, if you wish, but be concise.
Thank you very much, Your Honor. Thank you for giving me the floor.
Yes. Okay. I'll give him the thing.
Thank you, Mr. Fernandez.
Your Honor, first and foremost, allow me to thank you for giving me the floor to express myself on something which I'm totally convinced about and which I want to share with you. The specialist chambers, dear Judge, Your Honor, dear ladies and gentlemen. So I'm the first citizen of the Republic of Kosovo appearing before these chambers with a confirmed indictment. I wish to say a couple of words, or said in other terms, I wish to make a declaration, a statement in front of you today. I, the underlined Salih Mustafa, a former warrior of freedom and a former soldier of the KLA in Kosovo. Entrusting very seriously in the oath that I've taken as a soldier of the KLA, and at the same time trusting the morale of my co-warriors as well. Being convinced that the war for freedom and liberty by the KLA has been fair, inevitable, and at the same time indispensable, because of the long-standing occupation and the chauvinist and fascist occupation of the Serbs, with genocide dimensions run and directed by Slobodan Milosevic, as well as after many bloody wars of this person in Croatia and elsewhere in the region, myself and my people, I mean, we did not have many choices in front of us but take to war. So the choices out there were either to end up in the camps of somewhere in the Eastern Europe, with no motherland, with no honor, with no freedom at all. Or the other choice for us was to organize ourselves into a pan-dimensional resistance that culminated with the war of my country for independence and for a democratic state. Your Honor, fully trusting myself and my moral, my conviction as well as my character. So something that I have built over the course of the life in service of my motherland and in service to the way to freedom, but at the same time in service of the democratic institutions of my state, by respecting and honoring the friend countries that have assisted us a great deal into achieving our liberty, by being strongly convinced of the fact that the KLA has never ever been a terrorist organization or an organized criminal gang or enterprise, but it has instead been a liberation army that was born out of the people and which has, with a lot of sacrifices and a lot of will as well, and by giving the blood of the best of our boys and girls, has become a cornerstone of freedom that we enjoy today in Kosovo. I really wish to hope and trust that the specialist chambers would not be influenced by politics, be that the national politics or the international one, and neither would they be affected by certain interest groups and certain clans by wishing for the chambers to not be used by the enemies of my state against the nationals of my country and other official holders of my country, and by leaving aside those individuals or those groups of individuals, be them locals or internationals, that for narrow political interests, for their wealth or other low interests just simply related to them, are affecting the real foundations of our freedom, that is the fair war of the KLA. And at the same time, they are trying to crucify the warriors of freedom and liberty by making and perform the task of Lucifer for as long as the narrow interest and the greed of certain people have troubled their minds, and at the same time they are taken over by hatred and by greed, and they have sold their spirit to the devil. So I cannot find any other more adequate words for this category of people, but just the noble words of Jesus Christ. So the words that he shared at the moment of his crucifixion. So he said, God, forgive them because they don't know what they are really doing. Your Honor, I really wish to thank you for giving me this opportunity to issue this statement So thank you so much for giving me this ample possibility to express myself and trusting in justice, in the democratic values as well. I really wish to make myself available of this occasion to make an appeal from the chambers and I'm trying to appeal to the MPs of the European Parliament, to the MPs of the Kosovo Parliament, to the decision-making politicians of the European states, to the politicians of my motherland, Kosovo, and at the same time to the representatives of the justice system at the European level, to awaken their human awareness and consciousness, also democratic humanitarian consciousness, and to the selective specialist chambers that the annals of the European and international democracy is not recognized, it's not known. So I'm appealing to all these groups in order to extend the competences of these chambers in order to investigate and in order to try and give justice to 1,932 killed and massacred children, for 16 civil victims as well, for about 20,000 mothers and sisters of ourselves who have been sexually violated, for the restitution and return of 1,500 nationals of Kosovo that are still missing and disappeared, for hundreds of mass graves that have been discovered from Belgrade up to Rashkov, Serbia, for over 450 massacres that have happened everywhere in Kosovo, and for colossal damages, material damages, that have been caused on the economic, in the economies of the countries, but also on the social aspect of my country. So these are damages that have been caused by Serbia. Because I'm quite convinced myself that the reconciliation of the peoples is not achieved by this way. And this is not the way on how to achieve reconciliation, and that's obviously not the way by victimizing the victims once again. Nor can peace and democratic prosperity in the Balkans and in Europe itself can be reached by just trying to be good to the triangle, the autocratic, fascist, and chauvinist triangle that is composed of Alexander Vučić, Iris Dačić, and Alexander Vulin, who have been active stakeholders during the Milosevic times, and now, as derivatives of that regime, are themselves transformed into role players and key actors into the rooms and audiences and premises, and also in today's developments. These people, with their fascist policies, are hampering and are attacking the freedom and liberty of my people. So my patriots in Sanjak and in the eastern Kosovo are suffering because of them, by negating the fundamental human rights. Whereas, on the other hand, So they are affecting all the Balkan countries that are building their pro-Western European democracies. In this mission, they are being supported by their traditional and their long-standing ally. Hoping that these chambers are going to produce justice and nothing else but justice. Although I have not received a copy of the not censored indictment, and all the other relevant documents that are related to my case file, I wish to assure you, Your Honor, that in this legal struggle, in this legal endeavor with the prosecution office in front of these honored chambers, in every case and in every occasion, I am going to make use of only the truth and nothing else but the truth, and I will try to serve justice and to serve the right approach. I plead not guilty, and I'm ready to give my plea today. So I plead not guilty, and thank you very much indeed for giving me the floor, Your Honor. Thank you for your patience, and thank you for giving me the opportunity to address you, your distinguished excellencies. Thank you very much indeed.
Thank you very much, Mr. Mustafa. I mean, a lot of what you said was way beyond why we're here today, and I would like us to be focused on the case for which you are here today. I heard at the end of your presentation that you wanted to plead not guilty. I have to ask you the question for each count according to the procedure. So if you don't mind, I will ask you to stand up again, and I will ask you to plead for each count. So, Mr. Mustafa, how do you plead on count 1, charging you with the war crime of arbitrary detention?
I pafajshëm, zote gjykatës.
Not guilty, Your Honor.
You plead on count 2, charging you with the war crime of cruel treatment.
Not guilty, Your Honor.
Plead on count 3, charging you with the war crime of torture.
Not guilty, Your Honor.
How do you plead on count 4, charging you with the war crime of murder?
Not guilty, Your Honor.
Mr. Mustafa, as you have chosen to plead not guilty on all counts, the pretrial proceedings will continue with a view to preparing the case for trial, pursuant to Rule 95. This concludes the first part of our hearing today. We will now move to the second status conference in this case. The scheduling order convening the status conference contained an agenda of issues which I wished to discuss with the parties today, alongside with any other matters the parties wish to raise. However, before turning to this agenda, I would like to address the prosecutor's request for reconsideration of the order to file disclosure charts. This request concerns my framework decision on disclosure and evidence and related matters of 9 October. In this decision, I ordered the prosecutor, among other things, to file disclosure charts with each batch of incriminating evidence disclosed to the defense under Rule 102(1)(b). The framework decision also informed the prosecutor of my intention to request a consolidated version of these charts to be submitted at the end of the pretrial proceedings. Similar orders would also be made to the defense, should it choose to disclose any evidence. On 19 October, the prosecutor requested that I reconsider this part of the framework decision. In the alternative, the prosecutor requested that I certify this issue for appeal and grant suspensing effect to the order to file disclosure charts. Additionally, after the resolution of this issue, the prosecutor asked to be heard on the impact on the deadlines and requirements of the framework decision. On 23 October, I shortened the time limits for any response and reply which the parties may wish to file on this issue. I ordered the defense to either respond in writing by yesterday, 27 October, or to make oral submissions in today's hearing. I also ordered the prosecutor to respond either in today's hearing or in writing by tomorrow, 29 October. Before I give the floor to the parties, I would like to underline that this issue raised by the prosecution in its request is very important and not new in international criminal procedure. It has an impact not only on the obligations of the parties, and especially on the specialist prosecutor, but also on the expeditiousness of the proceedings. Mr. von Bonnet, I see that you have not filed any submissions in writing by the given deadline. Would you like to make oral submissions in response today? And please do so. You have the floor.
Yes, I do, Your Honor. Thank you very much, Your Honor. The defense has taken note of the order of the pretrial judge concerning the charts. The order was dated on the 9th of October and lies in the framework decision on disclosure of evidence and related material. The defense has also taken note of the prosecutor's request for reconsideration of the order concerning the charts, or in the alternative, leave to appeal the order to file disclosure charts. Indeed, Your Honor, the word or subject of charts does not appear in the law nor in the rules of procedure and evidence. The SPO, Special Prosecution's Office, states in his request that the pretrial judge failed to consider the legal framework before the special chambers relating to disclosure and case preparation, and failed to give sufficient or any weight to relevant considerations. Accordingly, says the SPO, the pretrial judge erred in the exercise of his discretion under Article 39 and Rule 95(2)(b). The SPO states that reconsideration is necessary to avoid injustice, including undue and irreparable irreparability on the fairness and expeditiousness of the proceedings. Now, Your Honor, before embarking on that issue, the defense would like to make some observations regarding the possibility to appeal the impunged order. Both Article 45 of the law, as well as the Rule 77(2) of the Rules of Procedure and Evidence, set the same standard for an appeal. It should involve an issue which would significantly affect the fair and expeditious conduct of the proceedings, for which, in the opinion of the pre-trial judge, an immediate resolution by a Court of Appeals panel may materially advance proceedings. Certification for appeal is therefore to be tested to this particular standard. Next to this, there is the discretion of the pre-trial judge under Article 39 of the law. Article 39 of that states that the pre-trial judge can make necessary orders or decisions to ensure the case is prepared properly and expeditiously for trial. It is the understanding of the defense that orders of the pre-trial judge must be viewed within this context. The defense believes that it is precisely this that was being envisaged by the pre-trial judge when he made that order. Whether this is a matter of error in the exercise of the discretion under Article 39 of the law remains to be seen or decided. But honestly, Your Honor, I do think that parties can and should be allowed to make submissions regarding an order, or if such order places a particular burden on one or both of the parties. That does not necessarily need to be before an order is given. Under Article 79, under 1 of the Rules of Procedure and Evidence, the pre-trial judge can reconsider its own decision. This rule, in the view of the defense, and gives the opportunity for the current dispute. I do not think that any of the participants in this trial wishes to duplicate any material. That is not practicable for any of the parties. I actually contacted the prosecution in order to have a clarification about the word chart and what is actually meant by it. A detailed outline that was given recently looks a little bit like a chart. And it is obvious that making it places a burden on each of the parties. In order to be practical, the defense gives into consideration whether both the SPO and the defense could maybe work out how a chart should look like, and then present that to the pretrial judge. This should be done within a short time frame and see whether the outcome would satisfy the pretrial judge's idea of how such chart is or what it should look like. I do believe, Your Honor, that Rule 79 under 1 would give a possibility to the pretrial judge to reconsider his order in the light of what parties would present to him. That may be, proprio motu, the order need not necessarily to be reconsidered, but only to be adjusted or specified to the way how such chart should look like and what it should contain. That is the submission that the defense wishes to make on this issue. Thank you very much, Your Honor.
Thank you very much, Mr. Van Bonnet. I will now give the floor to the prosecution, but before we proceed, I will just want to add two things. First one is that these charts are aimed not only at helping the defense to understand the case, because then you can understand all the evidence that is disclosed, but it's also for all the panels, especially the trial panel, in order to understand all the evidence that is disclosed as well. And for the SPO, I think one point that was raised by Mr. Fonbonnet that is very important is how such a chart would look like, because there are indeed different ways to do it. So you have the right to be creative in what you will present today. I give you the floor.
Thank you very much, Your Honor. For this particular point, I will turn over to my colleague, Ms. Lawson. Thank you.
Thank you. Ms. Lawson?
Good afternoon, Your Honour. As my colleague mentioned, I'm happy to address this. The Specialist Chambers has a unique and rigorous disclosure regime, which is reflected in the law and the rules. Rule 109C forms part of that framework and is itself a unique provision compared to the frameworks applicable at other courts and tribunals. As Your Honour noted, this issue is not new, and indeed we did make reference in our written submissions to certain jurisprudence where we thought it may be of interest or instructive. However, the key question is how to apply this unique provision, Rule 109C, before this unique institution, and most importantly, in this specific case. What Rule 109C requires is categorization as far as practicable. This is necessarily a fact-specific inquiry, and our request for reconsideration is not about a point of principle. It's about ensuring we have the opportunity to provide the court with relevant information that can help in giving effect to that rule in this case. In fact, what's practicable within the meaning of Rule 109C will vary from case to case before the Specialist Chambers. What might work in a smaller case will not necessarily work in a larger case. My submissions here will focus first on providing some of that additional information and context, which the court could not have been in a position to know at the time of making the order. And secondly, as alluded to by Defence Counsel, potential solutions. We have already had constructive conversations, a number of them, with Defence Counsel on this topic. And the SPO actually shared in advance the general nature of the submissions we intended to make here today, because I can assure you that it is in our interests to find a practicable solution appropriate for this case. What we understand practicable to mean is fair and proportionate, and what can reasonably be done with available resources, consistent with the overall disclosure framework, and without compromising the expeditiousness of proceedings. In terms of our office, it's a simple fact that the SPO is operating within significant resource constraints, as indeed is the defence team. Even at maximum capacity, we have a limited overall staff and an even smaller legal team. None of the team here today, indeed none of the lawyers in the SPO, have the luxury of being able to focus on just one set of proceedings. I mention this only to make the point that where a significant additional burden arises, beyond what was foreseen, there is a multiplier effect. Staff who must be reallocated to meet the new burden are taken away not only from priority tasks in this case, but also from such tasks in other cases before the court. When I refer to priority tasks, that's not simply a discretionary assessment that's being made by the specialist prosecutor. I'm referring to core functions under the legal framework, which are necessary, indeed mandated, in order to bring this and other cases expeditiously to trial. It is apparent from the legal framework that Rule 109C contains an inherent level of flexibility around what is practicable and was never intended as the principal or even a principal disclosure tool. It is a categorization insofar as practicable, which is supplementary to what is already a fulsome set of requirements mandated by the rules and accompanied by stringent timelines. Production of a detailed outline was obviously required at the confirmation stage pursuant to Rule 86, and we are pleased if it was of assistance to the Chamber and if it can be of assistance to the defence now. However, the additional burden of continuing to produce such documents, as the defence mentioned, is very, very significant. It is certainly not practicable for the SPO, and as we have submitted, would not be consistent with expeditious proceedings. In this specific case, in addition to the transcripts of the accused, the indictment supporting material consisted only of the evidence of 5 witnesses, together with a relatively small number of documentary items. And even though the SPO was able to draw on significant analysis and work product that had already been done throughout the course of the investigation, preparation of the detailed outline itself still involved the work of 6 people over several weeks. As outlined in the previous status conference, the remaining Rule 102B material is approximately double that size, involving at least 11 additional witnesses. We would consequently be contemplating an immediate delay of in excess of a month in these proceedings in order to produce the charts that were ordered, with consequent knock-on effects for all other deadlines. As I mentioned previously, the Rule 109 assessment will differ between cases before the specialist chambers, and our experience to date demonstrates that in cases of larger scope, and again working from detailed existing analysis, it was an exercise that took many, many months. Turning to solutions, hopefully it has been apparent from my remarks so far that the SPO is not fixated on a particular application of Rule 109. We will be as flexible as we can be within the constraints that we have. At the time of issuing the decision, the court would not have been aware of the categorization of disclosed material, which has already been done in legal workflow, and the manner in which that enables parties in the chamber to sort and navigate the material. However, in addition to that, we have been working to come up with alternative proposals on the format of charts that could assist both the chamber, a trial panel, and the defence. And we would be happy to continue working inter partes on that matter with the defence. If there's any further information that would be of assistance to the chamber, I'm happy to address it now or in written submissions as appropriate. Thank you.
Thank you very much, Ms. Lawson. Mr. Mustafa, this is a bit of a technical debate. I don't know if you understood everything, because it's a debate between lawyers all around here. What we debate here is when the prosecution will disclose evidence, how will they organize it, and will they categorize it in a chart so that it's understandable for you as a defense, and vice versa, if your counsel disclose evidence, how it has to be categorized so it is easily understandable by the prosecution. And as I was saying at the beginning, it's a question that we have in a lot of tribunals, because the risk is to have a lot of evidence that is sent to each party without being explained, categorized, and then you have hundreds of pages and nobody exactly know why they're disclosed. So this is, for you and for the public, I thought this would be probably useful. Mr. Van Bonny, is there anything you would like to add now after Ms. Lawson? And if I may, If I want to follow up on what was just mentioned, if there was an inter partes work on this, what would be the timeline for you? Would it be a question of days to find something acceptable? Or would it be a question of weeks? And how do you see it?
Well, honestly, Your Honor, I think on that part, I think we can work in days as far as I'm concerned. I'm making myself available to address this issue and work out something that is practicable for not only the parties, but obviously, ultimately, the trial panel that will need to visualize at some point where do I place this particular part evidence and where do I place that part of evidence. I have seen one document, a detailed outline, and that looked to me very presentable. But if there is any other chart that would categorize that maybe, then that is maybe a useful thing. So we can work out some kind of format, send it to the pretrial judge, and then if the pretrial judge believes that it is a practicable meaning of the word chart, then the entire issue of appealing or whatever could be avoided. And I think that each of the parties is interested in an expeditious trial, even if COVID issues might even hamper our investigations of both parties, I would say that. So I hope that the trial judge finds an option in the rule that I mentioned, and maybe stay the order for a bit in order to that we work out something and then send it to you. That is at least the option I'm available to give. Obviously, if I address some other issues, the prosecution has, in any event, always a more manpower than the defense has in a case. So it will give a burden. However, I must say at the same time that the type of issues that are brought about by the defense concern maybe not the exact same amount of issues that the prosecution is dealing with. After all, it is the prosecution that needs to seek beyond reasonable doubt a conviction, and therefore needs to prove that with evidence that is not only presentable but easily to be interpreted by the defense and the trial panel. I think that the order, therefore, could stay in place as long as maybe there is a precision of it or a amendment in how it would look like that would maybe avoid any procedural issues that we are then maybe that time we can use for something else. I do not believe that it is a very extreme principal point that is here the issue. It is a practicable issue that I think that all the parties wish to seek in order to have an expeditious trial. It is exactly that what I'm sure that Your Honor envisaged with the order as well. So there is, in that case, I hope, no issue between the parties. That being said, obviously, it is a lot of work, and even though it is a lot of work, such work can eventually help the rest of the trial to be much more expeditious. So I think there is also a responsibility for the parties to take that responsibility and say, well, here's what we're going to come up with, and is that a useful way of presenting it, so that during the trial all the parties can say, oh yeah, I can easily find this or that issue there. This trial is a single person. There is not a joinder or any other type of case where there is sometimes 3 or more accused. So it is in that case the burden is relative. However, if that is already too much, then I think a workable solution should be at least given the opportunity to do that. As I say, submissions can be, I think, in a status conference like this, also given like that, because I'm sure that the pretrial judge will consider those issues carefully and therefore then say what is the most practicable solution for this matter. Is there any other issue that I would want to address? At this point, not. I don't think that, no, I don't think I have anything else. Thank you very much.
Thank you very much, Mr. Van Bonnet. I think we are all in agreement here that we want to have disclosure that is both efficient and as detailed as possible so that everybody can understand the case. I think there is an agreement. What we want to avoid, and especially what I hear from the Specialist Prosecutor's Office, is they do not want this requirement to be counterproductive, meaning it will take so much time to do these charts that in fact it will have the opposite effect, meaning instead of being more expeditious, it will be less expeditious because it will take a lot of time. I will follow up with what you were saying, Mr. Van Bonnet. Ms. Lawson, if I may ask you a couple of questions. First of all, for you, is the issue, the principal issue you have with the idea of a narrative in the chart, like it is for the detailed outline, or is it the principle of producing any chart? And the second question I have is, you must certainly know that in legal workflow, which is the software we use to exchange evidence, there is an option to generate automatic charts with an Excel spreadsheet. Is it something that you could use, even if this chart is changed and you can add a couple of information, but is it something that would help in terms of workload if you were to produce these charts?
Thank you, Your Honour. I confirm it's not a question of principle around charts. We are, indeed, the solutions that we're discussing with the defence are in chart format. The narrative is obviously one of the very time-consuming aspects of a chart. However, what we are looking at is categorising the documents in chart format. In terms of automatic generation of charts, we're certainly looking at technologies both that we have in our office and through legal workflow that would assist in creating them and assist both parties. Finally, on timing, I can confirm, as the defence indicated, that I think it will be a matter of days that we can come back to you. We've already had some constructive conversations on the topic.
And if I may follow up on this, how many days do you think you need? Because I mean, you might have seen that I'm not the slowest usually. So is it a question of a week? Is it a question of 2 weeks? Because I wouldn't like this to delay the disclosure process for this case.
We understand that. I think it would not be more than a week.
So today we are the 28th of October. Would Wednesday next week be a reasonable deadline for you?
Yes, certainly, Your Honour. We will have come back to you within that time frame.
So I will then issue an oral order to the Specialist Prosecutor Office to come back to this chamber with a proposal on the disclosure chart after consulting with the defense. And I hope you will be able to make a proposal that is agreed upon by the defense in the meantime. And in the proposal, if you can explain what type of chart you would be able to produce, with what type of information, that would be of much assistance.
May I add something,
Certainly,
Your
Your
Honor?
Honor.
Mr.
Yes,
Fonbonnet.
I hope that the chart can become, as we go along in the case, a living document in the sense that every once in a while we can make adjustments to a chart or say that this is the basic frame, and if we have maybe experts or other issues that we can, more or less have some adjustments to it, so that it is not that we fix ourselves Wednesday on one particular chart, and if it doesn't work, then at least it could be adjusted. I think it would be helpful for all the parties, especially also the trial chamber at some point. Thank you very much, Your Honor.
Thank you, Mr. Fonbonnet. And I add to my oral order that to the Specialist Prosecutor Office, you can disregard the deadline of tomorrow for your reply, because this new order makes this response, I don't think it's very useful to have your answer by tomorrow, because we've had this discussion today in court. Is there anything to be said on this issue? Ms. Lawson, Mr. Fonbonnet? No? Thank you very much. We will now move on to the agenda for today's status conference, as scheduled, as set out in the scheduling order. I see that no written submissions were filed by either of the parties. I hope it means that everything went well in the disclosure process. As I noted in the first status conference, my goal today is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. I will ask the parties for their submissions in turn, and I remind the parties to give prior notice should any submission require the disclosure of confidential information, so that we can go into private or closed session. So the first item is the disclosure difficulties. I would like first to hear from the prosecutor on this first point of the agenda, namely whether there have been any difficulties in the ongoing disclosure process. Mr. Prosecutor.
Your Honor, thank you very much. We are not experiencing any difficulties for now when it comes to the disclosure process. Last Friday, on the 23rd of October, we disclosed to the defense the disclosure package number 8, containing 82 evidentiary items, including 5 redacted statements of witnesses. We also disclosed the detailed outline in confidential, redacted, and public redacted form, as required by Your Honor's framework decision. All this completed the SPO's disclosure obligation under Rule 102, Paragraph 1, Subparagraph A. On the same day, 23rd of October, last Friday, 2020, we also disclosed disclosure package number 8, and number 9, my apologies, Your Honor, under Rule 102.3, containing 11 items. We discussed that particular disclosure. This is a book in Albanian language, with some parts of that book translated into English. We discussed that issue during the first status conference on the 5th of October, and it is also, it's already done. We also sent an email to the defense on the same day, 23rd of October, in the morning hours, explaining in detail the packages that we disclosed on that same day. When it comes to difficulties, the only difficulty that we might face with regard to disclosure and the impact on the deadlines was discussed a few minutes ago between the defense, the SPO, and Your Honor, and it deals with the provision of the charts. So everything hinges on that issue. We hope that it will not have any impact if our discussions go well, smoothly, and as planned. Thank you.
Thank you, Mr. Prosecutor. Mr. Van Bonnet, do you have any comments on this, or did you face any difficulty with the disclosure process?
Not in particular as far as I am concerned. However, I have not been able to review all these documents at this point, and I'm not sure whether there are translations of it in the Albanian language. Obviously, the book is what I've seen in English, but I hope that all the evidence that is going to be used in this trial as evidence concerning my client and would support any kind of allegation, that particular evidence should be certainly in Albanian for the accused, simply because otherwise I'm unable to work with my client himself. My Albanian is quite rusty or non-existent, as I would say. So I think it is important that we are able to discuss this. So that's all that I have not been able to check that, but if there would be any issues, then I would. We have a joint communication line through an email. Then I could write down the ERN numbers and check whether that particular thing is in Albanian available, and if so, which ERN number that would be. So issues like that, I will try to do that inter partes as possible. Then we don't have any issue on that during a status conference. But I want to stress once again for the prosecution's office that it is important, extremely important for my client, that he will get all the material in Albanian as far as that will support any type of allegation. Thank you very much. That's all I have for this point.
Thank you very much, Mr. Van Bonnet. Mr. Prosecutor, do you wish to add anything on the translation question?
If I may, Your Honor, we fully understand the concerns of the defense in this particular regard, and I would like to inform the defense and Your Honor that the disclosed packages have been disclosed in the full translation into Albanian language. Thank you.
Duly noted. Thank you. I will now move to the second topic of our status conference, which is the investigations of the Specialist Prosecutor's Office. Mr. Prosecutor, I want to ask you about the status of your ongoing investigations. In particular, have you completed the investigative steps mentioned during the first status conference? And can you give an estimated date for the completion of the investigations? You have the floor.
Yes, Your Honor, thank you very much. The short answer to that question is no. We have not completed the investigations. There are still some limited investigative activities pending. We would not like to commit ourselves to any particular deadline when it comes to the completion of those investigations. However, I would like to make absolutely clear that our investigations that we are completing, and I said we're talking only about limited investigations, they are not going to impact in any fashion in the timetable set by Your Honor when it comes to the disclosure, which is for us of paramount importance. So we are not going to, as I said, investigate a lot from now. If there is any additional investigative steps that need to be taken at a later stage that go beyond the disclosure timelines, we'll of course inform Your Honor about that need, that necessity. And we'll also, in conducting our additional investigations, fully comply with the rules of procedure and the law. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Mr. Van Bonnet, do you have anything to add on this topic?
I have not.
Thank you, Mr. Van Bonnet. Mr. Prosecutor, when you say additional investigations, is it a question of weeks or a question of months for the time frame? I understand that, especially with COVID, it's difficult to set a deadline, but just to have an idea of how long this could take.
Your Honor, as I said before, I would like not to commit ourselves to any particular deadlines. It's for us very hard for the reasons related to the ongoing pandemic, but also for other reasons beyond the control of the SPO that unfortunately might impact on the scope of the investigation. But as I said, these investigations are limited in scope, and we try to complete all necessary investigative steps as soon as possible. And I want to again reiterate, these investigations are not going to have any impact whatsoever on the timelines for disclosure.
Noted. Thank you very much, Mr. Prosecutor. Now I would like to raise the issue of the pretrial brief. Mr. Prosecutor, I would now like to ask you for an estimate of when you would be able to file your pretrial brief and all the material pursuant to Rule 95, if you can already set a time for this, keeping in mind the disclosure calendar set out in the framework decision in this case. You have the floor.
Your Honor, with regard to that, indeed, we have a disclosure calendar set by yourself, which runs until late January 2021. We will try to do our best to file the pretrial brief and related material sometime in the end of February 2021. However, the main message I want to convey is that we would like to first complete with all our disclosure obligations and then file the pretrial brief once we perform all our obligations stemming from disclosure that we have. This indication, end of February, is just an indication. This deadline could move in either direction. Also, everything depends on the position of the defense, because the last deadline is given for us, and then the defense must also take some positive steps. After they've done that, we will know when we can finalize the disclosure and file the pretrial brief. Thank you.
Thank you very much, Mr. Prosecutor. Counsel, do you have anything to add on this topic?
No, Your Honor. Thank you very much.
Thank you. For the next point on the agenda, I would like to turn to the defense first. Mr. Fonbonnet, based on the information given by the prosecutor in relation to the other points on the agenda and the disclosure calendar set out in the framework decision, are you in a position to give any information on, first, the status of your investigations, second, any intention to give notice of an alibi or other grounds for excluding responsibility, pursuant to Rule 95, or any associated disclosure, pursuant to Rule 104, and third, any intention to make requests concerning unique investigative opportunities, pursuant to Rule 99. You have the floor.
Yes, Your Honor, I do have some things to address in that matter. As far as the status of the investigations is concerned, I should say that we have hardly started. Problematic is the issue of the COVID situation in the Netherlands. As yesterday there was a press moment of the Prime Minister and the Minister of Health, and it seems that particular measures that have been taken, they are in place until probably somewhere in December. That makes it not so easy to do research in the sense of contacting witnesses, interviewing witnesses, experts, or do any field work. Kosovo is at this moment an orange country. It's strange to say that in a country like the Netherlands, but Kosovo is the orange country, orange region, and problematic is actually more the Netherlands, which is a red region at this moment. So quarantine issues and so on, they are hampering, but I'm envisaging at least in the not so distant future to do at least a a mission which would take a little bit longer, and then I can update you on the status of those investigations and what they will deliver. As far as the notice of an alibi and grounds of excluding responsibility, at this point it is, as far as the defense concerns, still a little bit too early to give such notice, but we will. We have no disclosures at this moment yet to make pursuant to Rule 104.1 or 104.2 of the rules. We will do that in due course. That is certainly going to be the case. But at this point, I cannot make yet a particular time setting frame or whatever. Then unique investigative opportunities pursuant to Rule 99.1. No, I do not have at this point a particular request regarding that. Obviously, that is in relation to the other investigations that we are trying to endeavor, and that will take probably a little bit more time even than the initial investigations that we will take. So it's not much that I can give at this point, Your Honor, but I truly hope that the next status conference, if I may say something about that, could be a little bit in the more distant future, so that it gives the defense the opportunity to figure out a good moment to make a mission. Preparation of that mission is ongoing, but I must say that in order to do that, to do it properly and effectively, I need to make a proper time frame in which I would do that. I would think it would take about 14 days at least to be over there on the first mission, and then obviously that will give some results. So if the next status conference would be immediately in 4 weeks or so, I should say then I probably have nothing, or I should be on a remote location in order to participate in that status conference. So as far as I'm concerned, I hope that it would be somewhere in December rather than in November before we have any other status conference. Thank you very much, Your Honor. If you wish, I have two dates which are quite impossible.
We'll come back to that in a moment.
Okay, thank you very much.
Thank you, Mr. Fonboni. Just one thing to add to what you said. I perfectly understand the constraints that you mentioned. Just when you know that you want to raise any of these issues, especially the defense of alibi, please do so at the earliest opportunity so that we don't delay the proceedings. I think that's the most important. I totally understand that you are not in a position to do it now, but as soon as you know, as soon as you can, if you can please then get back to this to the court, that would be much appreciated.
I will, Your Honor.
Thank you very much. Mr. Prosecutor, do you have anything to add on this topic?
No, thank you. Nothing to add. Thanks.
Thank you, Mr. Prosecutor. Next, would either of the parties wish to raise a topic that hasn't been dealt with, that we haven't dealt with today? Is there any specific topic that you would like to raise, Mr. Prosecutor?
So we are not discussing the preferable date for the next status conference yet?
No, not yet. That's the next item. So just if there is any other topic, especially related to disclosure, that you would like to
Let me quickly consult with my colleagues if there is anything.
Of course.
Your Honor, there is nothing at this point that we want to raise. Thank you.
Thank you, Mr. Prosecutor. we wait a couple of minutes so that Mr. Fonbonnet can have a discussion with his client. Mr. Fonbonnet. Mr. Fonbonnet.
Thank you very much, Your Honor. We have no other issues.
Thank you very much. Now the last item is the date of the next status conference. Mr. Prosecutor, do you have any submissions on the date that would be the most appropriate for the third status conference in this case?
Your Honor, on this issue, as per the framework decision on disclosure, the prosecution has got one obligation on the 1st of December. We have to disclose a detailed notice of evidence under Rule 102, paragraph 3 of the rules. So if this is the case, and this is the case indeed, we would suggest to organize to hold the next conference in December rather than November. But of course, if the defense is of an opinion that we should, or Your Honor, of course, that we should have a conference earlier, like in November, namely once per month, we will not, of course, oppose to that.
Thank you, Mr. Prosecutor. Mr. Fonbonnet, I think you said that December might be better. What
Yes.
would be the best timeline for you?
Possibly not before the 9th of December, and the date of 16 December, please not. I just have a personal eye issue that I need to address at that day. So that would be suitable also for the investigations, and at least I have a lot of space. Thank you very much, Your Honor.
Thank you, Mr. Fonbonnet. Before we finish this hearing, Mr. Mustafa, I would just like to ask you if you have any comments about your detention conditions.
Io interrogo il giudicato.
No, Your Honor, everything is in order.
Thank you very much. This concludes today's hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned.
All rise.